हाँ बोलो।
Hello, check. Hello.
ये लोग डिफरेंट है। इसमें कॉन्ट्रडिक्शन है कि ना
आपका काम है
I mean,
I think that's-
Equality is not a concern. How they are presenting their arguments. What they, I mean,
Using the facts.
not concerned. How they are presenting their case. So it is legal profession. Even if you're wrong, but even the result is important. The legal result is very important.
Correct, correct. Necessary, persuasive qualities.
Good morning to all of you. You are ready? Shall we commence the proceedings? Or you want some more breathing time? Relax. No tense. The more relaxed you are, the more successful you will be. In fact, when we were just practicing or doing certain things, our seniors used to tell us, however hard you prepare, but just before argument, you must read some magazine or newspaper. To come out of that conglomeration of the mind, you must come out of it. Otherwise, you will be blocked. So they used to tell us, don't, you read, you work hard, but an hour or two before the arguments are commenced, read some magazine, India Today, Film Fair, or a newspaper, so that your mind will become clean. Otherwise, it gets jammed. Overcrowding is also very difficult. So, wish you all the best. Start. Time you are taking care of. Habita? Time aspect you are taking care of. Take care of the time is whatever, and they are told about that. Time constraints.
Yeah.
Because time constraints are very important. And you must cultivate this habit of maintaining time, because the judiciary, the oft-repeated comment against judiciary is arguments will go on for days together. So time constraints are very important. Try to be concise, precise, and brave. Yes.
Should I start? I'll start in 3, 2, 1. The council wishes your ladyships and your honors a very warm and pleasant morning. I and my co-counsel shall appear on behalf of the informants in the present case. Your ladyship and your lordship, of the allotted 40 minutes, I shall be taking the first 16 minutes. The next 22 minutes shall be taken by my co-counsel, and the remaining 2 minutes shall be reserved for rebuttals. Your ladyship and your lordship, I shall be addressing the first issue, and my endeavor is to establish that the discussion of quantities, even though different quantities were not before, amounts to collusion. If your ladyship and your lordship are well versed with the facts of the case, the council would like to move to the submissions.
Please go ahead.
Certainly, your ladyship. So primarily, the council has a three-pronged submission here. Firstly, that there was a horizontal agreement between the 5 opposite parties as according to Section 2B of the Act. Secondly, that the agreement resulted into bid rigging as according to the explanation of Section 3. And thirdly, that the agreement was likely to cause appreciable adverse effect on the competition. Your ladyship and your lordship, beginning with the first limb of the argument, that the discussion amounts to an agreement under Section 2B. It is submitted by the council that as was held in the case of Film and Producers Guild of India versus MAI, an agreement is basically a form of coordination which results into practical cooperation that reduces competition. Your ladyship and your lordship, here in our particular case, if you look at the conduct of the opposite parties, if you look at the points, firstly, that they had discussed the quantities. Secondly, not just discussed, they had overstated the quantities. And if you look at the bid results, even that is in very much coordination. And if we particularly look at the figures also, as if your ladyship and lordship would refer to page 5 of the Moot proposition. If your ladyship and lordship is with me. Here are the figures which are shown, that is the quantities that they had disclosed. They're so almost near identical. There were 600, 650, 650, 620 and 630 metric tons. And even if you look at the bid prices of the 4 out of the 5 opposite parties, they fall in the very small range of $131,000, $131,000 to $138,000. Your ladyship and your lordship, this particular form of coordination, which would, it also had an anti-comparative effect based on 2 grounds, which will be explained further also. But the 2 grounds are that by the very nature of the information that was disclosed, that was commercially sensitive in nature. And secondly, by the very object, that the 5 opposite parties had the object to rig the bid. And therefore, such a form of coordination, as is seen from the facts, coupled with the anti-competitiveness, the nature, the council here submits that there was an agreement as according to section 2B of the Act. Your ladyship and your lordship, if there are no questions.
I had one question. You said you're relying on the nature of cooperation for the 5 companies.
The form of coordination,
right?
certainly.
Now, in terms of that, then one of those 5 companies said nothing.
Certainly,
So it didn't give its quantity that it intended to bid.
your ladyship, FMI, I think it's the FMI that you're talking about. That is not one of the opposite parties in the case. So we are not alleging that FMI was
Three
included.
companies didn't participate in the discussion.
Certainly, your ladyship. And that is why
And one of those 3 companies is part of the 5.
Certainly, your ladyship. Your ladyship, that there is the fact that FMI, not being a party, was able to bid similarly and win, and the fact that Americar, being a party to the discussion, was not able to win the bid, is actually attributed to the fact that in such bid auctions, in such bid rigging, there is a form, a very common form. There is one called bid suppression, wherein one of the parties, or maybe few of the parties, they sometimes back out of the bidding, or they may bid lower just to ensure that the others are able to win. Your ladyship and your lordship, this particular fact is attributed that why Americar, being a party to the discussion, could not win. And secondly, addressing the fact about FMI, which did not discuss but was able to bid similarly, is attributable to the fact that such the nature of the market here was oligopolistic, and the fact that they were using the same algorithm. These are the facts why there was a parallelism, and it was a coincidence that FMI was able to bid similarly to the others.
Before we come to the bid algorithm, how is false information commercially sensitive?
Certainly, your
Because
lordship.
clearly, admittedly, the information was false, right? And there was no discussion between the various bidders that they would give false information. They went about doing the same on their own, but the information was nonetheless false.
Certainly, your lordship. Your lordship, the fact that these quantities was misrepresented are even more, the council would say, adverse to the interest of the other bidders. They were not just, commercially sensitive information was not just diverged, but also they were misrepresented. Both the facts are very anti-comparative per se by nature, and the fact that secondly, the fact that how even a misrepresented quantity would be commercially sensitive is because although the reasons that already there was a common algorithm being used, the fact that it was common factors on which the price had to be determined, thirdly, the fact that it was an oligopolistic market, these factors, they actually minimize the variables on which there would be decisions by the different eligible bidders to make their prices or bidding quantities. This minimizes the variable to mainly 2 variables, that is quantity and price, because there's similarity in other factors. So it boils down to 2 main variables, which is quantity and price, and one is being divulged by the 5 opposite parties and even misrepresented. This will, the council would like to draw your ladyship and your lordship's attention to para 29, page 29, para 16 of the compendium submitted.
Your arguments, we'll put.
Certainly, your lordship.
You
Your lordship.
Your arguments, we'll ask afterwards.
Okay, Your Lordship. Your Lordship, the fact that it was held in the Dole Food Company versus European Commission, that the disclosure of information exchange regarding individualized data regarding future prices or quantities, they reduce the uncertainty in the market, and regarding the time or extent or details of the market changes or behavior. Your Ladyship, in a Lordship, the fact that it was future intended bid quantities that was diverged, this will impact the other bidders regarding maybe regarding what would be the demand or what would be the price in the market, and this will impact their independence when they will be making their decisions. If this satisfies that how it was commercially sensitive.
So one small point with your permission. You
Sorry,
mentioned
ma'am.
that clarity on other factors. So can you just elaborate a bit on that?
The
So
fact,
what are- Yeah.
Your Ladyship, the factors that they were in an oligopolistic market where they're able to monitor and line each other's conduct. And secondly, the fact that it was common factors as given in the factual matrix, that based on which the prices were to be determined, like the purity, the weight of the ore, etc. And thirdly, the common algorithm which was being used. Your Ladyship, these all factors tell why there would be why the factors based on which they would be determining their prices can be common, and therefore, and that is why it boils down to two main factors, that it is price and quantity based on which it can be said they are commercially sensitive. If your Ladyship and Lordship is satisfied.
Proceed.
Certainly. Secondly, the council would like to submit that the parallel conduct here establishes the discussion amounts to collusion. Your Ladyship and your Lordship, it was held that if there is a concerted action and there is a parallelism found, and the reason behind the parallelism is the only plausible explanation behind the parallelism is the concerted act, then such a parallelism would amount to collusion. Your Ladyship and your Lordship, the council would like the bench to refer to page 5 of the Moot proposition. There are certain factors that the council would like to point at. Firstly, that there were that the bid range was per quantity price was $131,000 to $138,000. Secondly, even the quantities bid were in the range of 230 to 270 metric tons. And not just that, Your Honors, Your Ladyship and Your Lordship, the difference in the bid quantity disclosed and the bid and the actual bids, it is also very near identical. For Maxwell, it was 380. For Cromwell, it was again 380. For Dillon, it was 390. And for Brockwood, it was 410. Your Ladyship and Your Lordship, the council contends here that all this similarity to this extent, the degree of similarity here cannot be attributable to mere coincidence. There is an agreement because of which there is such an identical nature of conduct by the opposite parties. Your Ladyship and Your Lordship, the council, if you may, the council would like to move to the next submission. Firstly, next submission is that there was manipulation of the bidding process as according to.
Let us test that, identical range a bit. Between the lowest quantity and the highest quantity, there is probably a difference of 30%. 200 and 270.
Certainly, Your Lordship, but if we look at the whole table, there is a very clear difference between those who had disclosed and those who did not. We can see that the ones who had disclosed, they were 200, they were ranging from 230 to 270. While there is a very clear category that we can see from the table that the others who did not disclose, Bolger and Battenberger, there were 430 and 480. Your Lordship, why is there a very clear difference that the council can see in the table? It is attributable to the only reason that there was an agreement. Your Ladyship, in Your Lordship, the rest of the conditions, which, like as the council has already iterated, the oligopolistic nature, algorithm, etc., all these were common to all these 8. But we see the difference in the bid results, and that is why the council contends that there can be only plausible explanation behind this conduct is the presence of agreement. If Your Lordship is satisfied, the council would like to
Just
conclude.
one more
Certainly.
question on this aspect. The input and the data which has been fed appears to be different in terms of prices and quantities. So then how do you explain, or how do you kind of attribute it to the algorithm?
Your Ladyship, you talking about the inputs in the algorithm? Your Ladyship, firstly, it will be dealt by my co-counsel, but it is contended that there was a common data pool which was being used. It was a common data pool which was being used, and that is why even the points that the council had pointed out, there were common factors, etc. These actually point out why the algorithm would also result, and the fact that all of the 5 opposite parties, they knew that each of them were using the same algorithm. This is basically the predictable agent scenario, which again would be talked about by my co-counsel. Coming to the next submission, that there was a manipulation of the bidding process as according to explanation of section 3, clause 3, which says the council contends this on 2 grounds. Firstly, the council would request your leadership and your lordship to refer to page 27, para 2 of the compendium submitted. I shall continue. That it was held in the case of Hulse versus Commission that if an undertaking receives a commercially sensitive information, then it is presumed that such an undertaking would act upon it, would take it into consideration while deciding its own strategy. Therefore, your lordship, it is contended that there was infringement of the independence of the other eligible bidders because the nature of the information exchange was commercially sensitive. Secondly, on what ground manipulation of the bid process happened is due to the reduced uncertainty of the other bidders. It was held in the case of, as already pointed out, in the case of Dole Food Company versus European Commission, that such an information exchange reduces uncertainty regarding the market change, market behavior, etc. Your lordship and your ladyship, here in the case, the other bidders might have pushed their own prices, thinking that the demand is so high of the Franconium, or they might have lowered quantity for the Franconium, or they might have been deterred by the dominance of the other 5 OPs. So there can be several ways in which the bidding process was manipulated.
But the first one that you pointed out, actually, the bid prices of the unsuccessful bidders were, in that ballpark only 110, 111 as opposed to 130.
Certainly.
So really, the quantity was vastly different. So how did the demand situation affect their price? That doesn't seem to be coming out of the table.
Your lordship and your ladyship, why such bid results actually came like this, because that is how could opposite parties win, is because when the others had increased their prices due to such high demand, due to such creation of perception of high demand from what they had intended, they must have increased. And secondly, they had bid a high quantity, failing to realize that the other opposite parties will actually lower their quantity. So although they increase their bid prices, because the prices evident from the table is more than the opposite parties, so they increase their quantity, but they failed to increase their prices as well, because they didn't realize that the 5 opposite parties would be lowering their quantity, because in such bid auctions, it is basically the per quantity price that matters. And because the opposite parties had misrepresented, the results came out like this, and the 5 OPs could win and the others could not. The 4 out of the 5 could win and the others could not.
So if we are to accept your argument that everybody has been beneficiary in terms of the receipt of this information, even if it's manipulated information, and therefore it has reduced uncertainty, why have you not made all 8 a party? Why is it that you've only focused on the 5?
Your ladyship, because here, as the council contends that there was meeting of mind, they had a common object of rigging the bid, which the council believes is an requirement for establishing an agreement. And the act of disclosing the information was done only by the 5 opposite parties, and that is why the others did not.
FMI didn't disclose. One of the 5 has not disclosed.
Your ladyship, the council, FMI is not one of the opposite parties. It was in the clarificatory question 4, page 1 of the clarificatory questions, that it was written the 5 opposite parties who had disclosed the quantities. So FMI is not one of the parties that the council is.
But there's nothing on record to show that kind of they disassociated from the process. So you can go ahead. But
Your ladyship, but the fact that they were even, although FMI could win, but the 2 others could not, because as your ladyship had pointed out, that they were beneficiary of such information exchange. However, the council contends that instead of using the word beneficiary, maybe we should say that they were manipulated and it was actually adverse to their effect, and they weren't benefited by it. And this brings the council to this last submission, which is that the agreement was likely to cause appreciable adverse effect on the competition. Your ladyship, in your lordship, it is in cases like industrial automotive bearings versus ABC bearings, and also under section 3, clause 3 of the act. The council would like to extend just 1 minute. It is held that if an agreement is found in contravention of section 3, then it is presumed that there is an appreciable adverse effect on the competition. and therefore the council concludes that the kind of conduct of the 5 opposite parties satisfies all the requirements to establish an agreement. If it was pleasure arguing before the region.
No, other than the quantity and the pricing factor, presuming that there was a cartel formation, what basis you are coming to the conclusion that there was some cartel formation?
Uh,
Other than this, anything with you, any information with you that they have tried to adversely affect the competition in the market?
Your Lordship, the council contends that there was an agreement based on looking at the the parallel conduct, because Your Lordship, an agreement, it was held in cases like re-alleged cartelization by Cement versus Sri Cement Limited, that such an agreement can be merely through a nod or wink. Your Lordship, there is rarely direct evidence of such agreements, and that is why it is through the conduct sometimes that the council would say, often it is through the conduct that we have to come upon the conclusion whether there is.
Are you not presuming too much
Uh,
about the farmer syndicate and all that?
Your Lordship, the council contended only on factual matrix. If there is any particular question the council would like to answer. It was a pleasure arguing before Your Lordship and your leadership.
Thank you.
Over to my co-counsel.
Commission may just permit 10 seconds to arrange myself. Yeah, can I start my time? Members of the Commission, as my co-counsels dealt with the first issue, I shall be dealing mainly with the second and the third issue. The second issue concerns itself whether the usage of the same algorithm to determine prices amounts to a situation of tacit collusion. Now, Commission, what is tacit collusion? Tacit collusion can be defined as uniform or parallel conduct that is accompanied by plus factors in the market. Now, having laid down this definition, the council will be going ahead with to make a three-pronged submission based on this very definition. My three-pronged submission is as such. One, that the usage of the same algorithm constituted tacit collusion. Second, the plus factors produced a conducive environment for collusion. Third, the similarity in prices goes against the established tenets of consumer harm principle. Now, before proceeding ahead with the arguments, one important ground that the informants want to establish here at this stage is that as per Section 3, only a preponderance of possibility needs to be established by the informants, where the threshold is of a lower stage for the informants in this case, where if normal human conduct permits, then there will be a strong presumption of collusion. Coming to this, the council would like to come to my first ground. This will be divided.
Sorry. Just to clarify, preponderance of probability will apply insofar as a 26-1 order will be passed. For a prima facie order, you're also arguing for interim relief, and that's not the standard.
Your Lordship, Your Ladyship, the council contends that for interim standard, for interim orders, there are other standards that would be established in the third issue, whereas for this particular issue, the council will be dealing with the preponderance of possible. If the council may continue, that in the first ground, I've established two main sub-arguments. That one, there's similar prices between the competitors, and second, the usage of the same data pool has constituted tacit collusions or conditions for tacit collusions. Now, if you may just come to my first sub-argument, that is similarity in prices. If I may lead the commission to page number 5 of the Moot proposition. We're both on the same page. The commission may observe that the EV companies had quoted bid prices at a very similar price range. In fact, they quoted at a price range of 130,000 to 138,000. And these were the only ones that had access to the algorithm that had in fact won the bid. So the council contends that this price coordination is only among the companies that had used the algorithm. Further, if the council may point the commission to the company.
You may correct me, but all 8 had the algorithm with them.
Certainly, Your Lordship.
So therefore, the fact that the prices of 5 bidders were close to each other is not necessarily attributable to the algorithm.
Yes, for answering this, the council like to come ahead to the first definition that the council had established of that of tacit collusion. That is a parallel conduct accompanied by plus factors, which will be laid down by the council in the second ground. Now, if I may continue with my first argument, Your Lordship, if that answers your question. If the commission may refer to page number 61 of the compendium that has been submitted. Your Lordship, in this case, the case of aluminum phosphate tablet manufacturers case, particularly para number 7.32 of the judgment by the commission, this honorable commission had itself had held that if there are instances of uniform conduct by the parties, but if it does not conform to the normal conditions of the market, then it can amount to a concerted practice. Now, it is very relevant to look at the particular market in this case, not the relevant market, but the particular bid, that is the Franconium ore and the particularities of the bid process itself. So the council establishing two main factors over here, your lordship and ladyship, that of the unique market situation and that of the variables that are there in the bid process. Now, out of the more than 60 bids that are submitted, it could not have been a mere coincidence that only 5 of them, and that too 5 of them who had access to the algorithm, could have won the bid. Further, looking at the variables, your lordship and ladyship, there are more than 100 variables that are there. It could not have been a mere coincidence that out of all these variables, that all of them at the end had arrived at a similar pricing, and that too when the variables are different for each of the companies. So the council contends that this bid process does not reflect normal market conditions, as otherwise the benefits of the auction process should have been distributed to other participants of the market as well. If I may come to my second sub-argument regarding the usage of the same data pool.
The algorithm was available to everybody to purchase, right? And it was widely known and reported also that the 8 bidders had purchased the algorithm.
Certainly.
So there was no barrier to acquiring the algorithm.
Lots of the council may like to point out in the factual matrix that all of them were actually looking for some mathematical formula in order to arrive at the final price. However, what happened was that the bid AI was only released 3 days prior to the bid. And it was this thing that the OPs in this particular case had access to the algorithm. And further, they'd gone ahead, they met at a government convention, and they'd in fact gone ahead to discuss quantities. Now, for this, the council may like to rely on the case of Ethuras. If the commission may come to page number 46 of the compendium, para number 46 and 49. In this case, the court had held that if there's a presumption of collusion, and if the parties do not take any conduct to distance themselves from such presumption, then they can be held liable for concerted action. Now, in this case, the council like to bring forth the case of a predictable agent scenario, where the OPs, each of them were aware that each of the others were using the same algorithm, yet they did not take any steps that would distance themselves from such presumption of collusion. Rather, they'd met the night before and they'd exchanged quantities. Therefore, this constitutes a very strong evidence in favor of collusion. Now, if I may continue with my second sub-argument regarding the usage of the same data pool, much obliged, Your Lordship, I would like to refer to my co-counsel's argument on how the exchange of quantity information had reduced the uncertainty between competitors and is thus restrictive in nature. Now, Your Lordship and Ladyship, when companies enter into a bid process, there are a lot of factors that are very uncertain to each other, and they do not know what the other party is going to bid for. However, if in this case the parties are aware of the quantities that the other parties are going to be bid for, then that would reduce the uncertainty in the market, and it would create an artificial transparency in the market, as has been held in the case of Doleford, that has been provided in page number 30 of the compendium, para number 121 and 122. It had held that the exchange of information had created an artificial transparency, and this information was of a commercially sensitive nature that was individualized to each company. In this case, Your Lordship and Ladyship, the quantities were very individualized to each of the companies, and yet they'd gone ahead to disclose this, and this resulted in them having a common data pool that resulted in them having the end outcome that was achieved through the algorithmic collusion. Now, if there are no questions in the first ground, the council would like to move ahead to the second ground, that of the plus factors. Your Lordship and Ladyship, what are plus factors? Plus factors can be defined as economic outcomes that go beyond and above the parallel conduct of the parties, and which helps to establish or arrive at a definition or an explanation of the similar pricing between the parties. Now, the informants in this case have identified 3 main plus factors. 1, the small number of firms with the license. 2nd, that they'd met the night before and they'd exchanged quantities. 3rd is that of the predictable agent scenario that the council had argued earlier. Now, coming to my first one, that there was a small number of firms with the algorithm. Your Lordship and Ladyship, if you may refer to page number 65 of the compendium, in the case of Interim and Co., this Honorable Commission itself had held in para number 39 that when there are a small number of firms who have a higher market position than the other players in the market, then that could constitute a very strong plus factor. Your Lordship and Ladyship, analyzing this with this present case, whether the limited number of firms with the license who could acquire the license, and it was only these firms who could complete the bid on time, ensure that they were in a superior market position compared to the other competitors in the market. Therefore, this is one.
But here, how would you attribute the conduct to them? Because as was mentioned earlier, the algorithm was available. And at the outset, they may not have known that only they will be going for it. In that sense, it's only after they have acquired the algorithm that the set became smaller
If
for basically bidding. So, and they're also not all of the firms have at least explicitly shared the information. And
Yeah.
the presence of some of the entities, which at least on the face of it are not part of it, how do you then say that this plus factor is satisfied?
Your Ladyship, first, if the council had established that they were aware of the usage of the algorithm by each of them, and they'd met at a common government convention, which is a public event. And the fact that only the people who had access to the algorithm, it could not be a mere coincidence that they had come together at that particular stage to discuss how they had achieved the success in achieving the algorithm. Further, they'd gone ahead and discussed the quantities between each of them. And this is what the council is contending in this case, that not just parallel conduct of the usage of the algorithm, but the fact that they had constituted plus factors. Now, if I may just come to the third plus factor that I had mentioned before, that is the predictable agent scenario, where they know that the algorithm is programmed in such a way that when you enter the inputs, the price would only come out in a certain way. Now, Your Lordship and Ladyship, one particular factor that the council would like to highlight over here is that there are certain factors that had to be determined when determining the price of the Franconium ore. And this relates to the weight of the ore, the purity of the ore. However, there are some other factors which are relevant to each company's finances itself, or relevant to each company. So the weight of the ore, the purity of the ore, these are factors that are relevant to the Franconium ore, whereas other factors are relevant to the competitors themselves. And if the factor of the Franconium ore is very common among the parties, and the only thing that can make a differentiation in the prices in the market is that of the individualized data of the company. However, if they've gone ahead and shared this in this particular case, then that can amount to a situation of collusion in a predictable agent scenario where the algorithm is programmed in such a way.
So you are a professor in competition law, I suppose.
Yes.
Let us just test what this algorithm has done. Basically, with people who thought that there was higher demand in the market, they have ended up putting lower price. So
Yeah.
how does it prove this predictability that you are sort of trying to establish? If people felt or the algorithm was using the data of the quantity to throw up a price, then people with information or ostensible information that there was a higher demand in the market should have quoted more.
Your Lordship, what has to be of relevance over here is the per quantity bid price. So if Your Lordship may refer to the table in page number 5, that the winning bidders had a very high per quantity bid price, whereas the ones who did not win the bid, that they had quoted 450 tons, yet they had quoted a price that is lower. So Your Lordship and Ladyship, further relating to the difference in quantity, the council like to answer this in threefold manner. One, there's a very proportional reduction in the quantity that can be seen. If the commission may refer to the table that is provided, they'd gone from 650 to 240, and all the companies had reduced in a very similar proportionate manner. Therefore, a kind of agreement can be seen over here. Second, the common object was still achieved in the end. When the parties met in the government convention to decide the prices that they would be deciding, there was a common object. And this common object can be seen in the end, that is carried out towards the end itself, where they quoted the similar prices. Third one pertinent factor that has to be considered is that of the pattern of inflating the price and lowering the quantity when bidding. If the commission may see that all the winning bidders had quoted a higher price and they quoted a very low quantity, and this ensured that they would win the bid. Therefore, this ensures that this is enough to show that the threshold of preponderance of possibility is satisfied in this particular case. If the commission is satisfied with the arguments, the council like to go ahead with the third ground.
But it's not for all the winning bidders, right? Because FMI is not in that.
Yes,
Of your 5, the companies that you have complained against for alleged cartelization,
Yes.
it is FMI who's one of those 5.
Yes,
And
Your Lordship.
FMI did not disclose.
No, Your Lordship, but it is very clearly mentioned in the clarificatory questions that FMI had access to the information. That is, they had overheard the discussion of quantities that had happened. Therefore, there is nothing that prohibits FMI for going ahead. Further, if one pertinent factor that the Commission may observe is that the disclosed quantity that is there is of a amount that is more than 3,000. However, the relevant market, that is BG40, is only of 2,800 quantity. So FMI, who might have been a prudent competitor in the market, would have recognized this and saw that, okay, these companies were actually quoting a much higher price, so they would have to quote a much lower price in order to win. If the commission is satisfied, the council would like to go to the third ground.
Please go ahead.
The third ground, the council would like to refer to the preamble of the Competition Act, which states that the protection of consumers in the market is one of the main purposes of the act itself. Lordship and Ladyship, instances of bid rigging can undermine the benefits that would normally accrue in a fair and competitive marketplace. And the intent of the government here was to replace lithium-ion batteries so as to preserve the environment. Lordship, when the companies had quoted a much higher price than the others, this had inflated the prices in the market. And this would eventually affect the consumers in the end, as they would be affected by the price of the franconium in the EV cars. And therefore, the council established that this has harmed consumers in this particular case. If there are no further questions, the council would like to move to the third issue, that the remedies fall within the scope of the act and address the potential harm. The council shall be dealing with this on a mainly three-pronged submission that one, a prima facie case is presented. Second, the BCA can direct the reauction of franconium. And third, they can appoint a monitoring agency. Coming to my first ground, as laid down by the council earlier, at this stage of the dispute, only a preponderance of possibility needs to be established, where for a prima facie case to be formed. And considering the factors that are argued by the council earlier, that they'd met the night before, they'd discussed the quantities, they'd all proportionally reduce the quantities to to less than half. These are all factors that can be taken into consideration to show that a coordination is evident between the parties, and therefore prima facie case can be presented. Now, if the commission is satisfied, the council would like to come to the second ground. For this, as per the Mines and Minerals Act 1957, the jurisdiction of mines falls under the central government. However, this particular act is silent on what would happen in cases of antitrust or anti-competitive conduct. And this is where the Competition Act comes in, which is specialized legislation meant to deal with all cases of antitrust issues. And therefore, the BCA, the Barrack Competition Authority, in this case is empowered to deal with such issues. Now, coming to whether they can direct reauction as part of my second sub-argument. The council would like to refer to section 33 of the Competition Act, which states that the commission can give interim orders in this case. So for this, a threefold test, as the commission had mentioned earlier, the threefold test the council will be establishing over here, and this was seen in the case of CCI versus SAIL. One, a strong prima facie case has to be established to pass an interim order. Second, it is necessary to issue such an order. And third, the balance of convenience is in favor of passing the order. As argued earlier by the council in the first ground of the third issue, there exists a prima facie case to pass an order. And coming to my second sub-argument, that it is necessary to issue such an order. The commission may refer to the benefits of the franconium, that it would inevitably result in preserving the environment for the whole of the benefit of the country. And over here, the unfair allocation of franconium has harmed public interest and has caused an appreciable adverse effect. It has also harmed consumers in the end, as they would be subject to the high prices in the market. Third, the balance of convenience. Your Lordship and Ladyship, the Council contends that there has been no harm in this case, and further, the only positive benefit in this case is that of eliminating collusion. No harm can be provided over here, as that even of appointing a monitoring agency or bringing about a reauction would only be in the benefit of stopping collusion in the market. Therefore, a balance of convenience is in favor of the informant party in this case.
I have a problem with the issue of balance of convenience. Have you thought through? Because, the franconium has a very short shelf life. How can re-auction be done and, the mine mineral would all become waste? So why should we sort of allow a national waste in this fashion? That is number one. Number two, as you have seen, with regard to your remedies that you suggested, the behavioral, that you should disclose your matrix to the national authority or some agency. Can the national authority give a decision in 2 hours' time, which is the time within which the bids have to be sort of formed up? That's the time given, right, for forming up the bids. So, I mean, both the remedies that you've asked for are actually impractical. There can be certain other remedies which can be taken in the form of say, penalties and disgorgement if you're right later, but these remedies don't work in this present case.
Thank you for the question, Your Lordship. Now,
Can't you be compensated?
um, if I may start with Your Lordship's question first. If the commission makes refer to the compendium provided, page number 2 of the compendium,
Yes.
this is a very pertinent factor that has to be observed.
Yes.
The question number 12, the clarificatory question number 12.
Okay, what
If
is
Your
it?
Lordship is with me, it stated that the ore is already in possession of the companies that have already won the bid. Your Lordship, it is an accepted factual matrix that the ore would get degraded after a point of 2 hours. And since the parties in this case have already won the bid, it is a very logical and natural scenario that they would take the ore and process it so that further degradation can be prevented. Since the ore is in possession, there can be a very strong assumption that the ore has already been processed and therefore degradation is stopped. Therefore, this does not go against the practical inconvenience that the commission, the Honorable Lordship had pointed out.
So how are they going to get compensated for processing the ore and applying the technology and capital to the processing of the ore? Now you're saying it's become a different product now. It's a processed ore, whereas the bids were for ore. So therefore, how can you compare the two?
Your Lordship, if I may just come back to my earlier argument about the preamble of the Constitution, how the protection of the consumers.
I'm with you completely that there, if you are right, there must be some remedy, but the remedies you have sought are impractical. That's all I'm saying.
Your Lordship, in this case, the very aim of the Competition Act is to prevent collusion in the market. And if the Commission itself is complicit in allowing parties who have colluded.
Are there other remedies you could look at potentially which could sort of even the pitch that you're saying you're complaining of?
Your Lordship, what has to be considered in this factor is that of the absurd scenario of this factual situation. This is a very new market that is there, and therefore it is pertinent.
We have other powers or remedies which we can provide you if you are right.
Your Lordship, there are powers that are provided under interim measures and also maybe under Section 27 also where.
Can you elaborate slightly on those?
Your Lordship, under Section 27.
Yes, what are the powers that you think can be exercised if you refuse to go along with the remedies that you have suggested?
Your Lordship, if I may point to Section 27, Clause G of the Competition Act, it states that the Commission vested with wide powers. Now, in cases it has been held that this wide power cannot be an arbitrary power. There has to be a proportionality of the remedy. And so, since the Frinconium is a new market, the concerted practice by OPs has foreclosed the market to the other competitors. And this has harmed consumer interest in this case and the scope of innovation in all future products. Your Lordship, since this is a nascent market, they cannot go ahead to permit collusion in this case, as it would set a very bad precedent. And since the market situation itself is such that. Since the market situation itself is such that it's a very absurd situation, the Commission itself has to come up with remedies that would address the particular situation. Your Lordship, and further, this is a very interim measure or a very temporary measure so that until there are future algorithms in the market, it is just a measure to take care of this particular algorithm itself. Once future algorithm.
Right, we can order disgorgement or penalty. Do we have those powers?
Certainly, Your Lord.
So why should we give the interim orders that you're asking?
Lordship, since this is the first auction of Frinconium, and if the participants of the auction, they come in the beginning itself and they establish a dominance in the market, then it would foreclose the market to the other competitors in the market. Yes, Your Ladyship.
Council, under the Competition Act, dominance only applies to one player, not 5.
Thank you for the clarification, Your Ladyship. But if we may come back to your question, Your Lordship, that the very aim of the Competition Act is to protect consumers. And further, this is a very temporary measure until there are future algorithms in the market. And this is only for the particular algorithm bid AI only to ensure that in the future, when there are future algorithms, parties can have a choice of choosing other algorithms and there would be no situation of collusion in this case. If Your Lordships are satisfied with the argument, just I would like to conclude with
Sure, please.
the second sub-argument that the disclosure of bids would address the harm arising out of the alleged cartel. Now, the disclosure of bid metrics would bring in objectivity and fairness into the procedure, whereas subjectivity breeds collusion in cases. And further, the OPs are not prohibited from taking part in further auctions or future auctions. They can still go ahead and submit their bids, provided that these bid metrics are analyzed by the monitoring agency to ensure that it does not amount to a collusive outcome. Therefore, the council concludes that the remedy sought is in accordance with the purpose of the act and address the potential harm that has been caused here.
So just
For
one,
grant of interim injunction or relief, the three factors are there. Three factors are to be able. You are
Certainly.
arguing about two. What about the third point?
Your Lordship,
3 points for injunction?
Uh,
Prima facie case?
that it should be
Of convenience and
necessary to issue such an order. Your Lordship, the council had established the arguments. If the commission may, I can come to the arguments once again. That one.
yeah, just wanted to understand by asking them to disclose and then saying that the outcomes should not be anti-competitive. Are you not taking away the very fundamental independent, ability to intelligently, kind of take into account, irrespective of access, without access to commercially sensitive information?
Thank you for
Because,
the.
there can be outcomes which independently also are arrived at. How will then that be distinguished?
Thank you for the question, Your Ladyship. But one factor that has to be pointed out here is that the monitoring agency is not abdicating the powers of the commission. It is just deciding whether, based on the bed metrics that have been supplied, there might be an instance, and the final decision is in fact taken by the Honorable Commission itself, and not the monitoring agency. Therefore, there is no abdication of power in this case.
Council, if you feel it necessary, that basically you need these bid metrics of the 5 companies, why have you not asked also for the AI, the algorithm itself?
Your Lordship, first, the council like to point out that the bid AI is not what is causing the algorithmic collusion in this case. As in, the council like to clarify that the algorithm is coded in such a way that when you enter inputs, then it would result in a price. Therefore, the algorithm itself is not acting. The council is not containing a hub and spoke model or anything like that, where the algorithm itself is storing information or dispersing the information to the users of the algorithm. Rather, the council is contending that the 5 OPs themselves had colluded in this case and not the algorithm. So, if the commission may observe that we have not pleaded aperture in this case as a party. If there are no further questions, the council would like to move to the prayer. It is a pleasure arguing before the commission. The council is done, Your Lordship.
Thank you.
Greetings to the honorable bench. Your Ladyship's permission to address the bench collectively is Your Lordships. Much obliged. Your Lordships, both the council will together taking 40 minutes of this court's time. Council number 1 will be taking 20 minutes, while council number 2 will be taking 16 minutes, while we'll be saving the rest of the times for the sir rebuttals, if there will be any. Lordships, moving further, there are 3 matters at hand. I'll be dealing with issue 1 and 2, and my co-counsel will be dealing with issue number 3. If your Lordships are satisfied with the scheme of the arguments and have no query regarding the facts of the case, the council seeks permission to move to the issues. Much obliged, Your Lordships. So, Your Lordships, the first issue at hand is whether the act of these opposite parties amounts to collusion in the present matter. Your Lordship, the council humbly submits that it does not amount to collusion in the present matter. The argument will be dealt in a twofold manner, Your Lordships. Firstly, I'll be establishing how there is no violation of section 3 in the present matter. And secondly, how the OPs have not cartelized in the present matter. Moving on to the first fold of the argument, Your Lordship, it is further dealt in a 3 subpart manner. Firstly, that there is no implementation in there is no agreement in the present case. Secondly, that argument, even if we believe that there is an agreement, there is no implementation in the present matter. And thirdly, again, arguendo, even if we believe that there is an agreement, there is no appreciable adverse effect on competition, Your Lordships. Now, Your Lordships, moving ahead with the first subpart of the first fold of the argument, that there was no agreement. Your Lordship, when we go through section 2B of the Act, agreement is defined. However, a conjoint reading of section 2B along with section 33A would establish that the agreement should be of determining prices, Your Lordships. Moving further, Your Lordship, please refer to page 1 and paragraph 4 of the memorials. Are Your Lordships with me? Much obliged. So, Your Lordship, here in the case of Builder Association of India versus cement manufacturers, it was clearly held that meeting of minds is a sine qua non for an agreement, Your Lordships, and that has to be established. Further, Your Lordship, in another case, it was held that it is needed to be established conclusively that there has been a collective decision, Your Lordships. Your Lordship, here, when we refer to page 4, paragraph 2 of the proposition, are Your Lordships with me? Your Lordships, here, it has been clearly given that it was a celebration rather than a meeting in the present matter. Further, Your Lordship, here, various eligible bidders met. Also, the invitation was by the Baraki government. Further, Your Lordship, here it has been clearly given that naturally the conversation came up, and that too, the discussion was in a very casual manner. Further, Your Lordship, the main argument is that there was no meeting of minds here. Your Lordship, for that, we need to refer the line where it has been said that in a fleet of mind games and with the intention to mislead each other, 5 of these CEOs, namely Maxwell, Cromwell, Dillon, Brookwood, and America, misrepresented and overstated the quantities. Further, Your Lordship, when we refer to all of these facts, it's very clear, Your Lordship, that in the present matter, there's no meeting of minds of these 5 opposite parties.
So don't you think softening of competition also amounts to meeting of mind? It need not be that, it is the final outcome is exactly what is determined, but it compromises the independence, the very discussion. And why is there a need for discussing commercially sensitive information?
Right, Your Lordship. Lordship, for that, I'll be referring to the clarification. Is there any other question?
One more question to exactly what my
Yes.
sister judge has asked you. You've used the words naturally, casually, right? The definition of the agreement which you were referring to says oral, written, understanding, action in concert, right? So natural, casual, the setting is irrelevant, 1. And 2, when there has been reduction in strategic uncertainty with none of the 5 disassociating from it, can you still argue that this is not an agreement?
Your Lordship, the main argument revolves around meeting of mind. So, Your Lordship, when 5 parties, it's not 5 parties who are discussing, it's 1 party who's trying to mislead the other 7, Your Lordship, in the present matter. So, Your Lordship, further, when we refer to the clarification 54, page 8, it has been given that the total quantity was in 2,800 tons. However, Your Lordship, when we calculate the total quantities that were put forward in the discussion by the 5 OPs, the total comes to 31550. So, Your Lordship, here, if the other 3 parties would apply their minds, they'll actually understand that it is impossible to bid for the categories mentioned here. That is 600, 650, 650, 620, and 630, Your Lordships. May I move further with the arguments?
But, I just wanted to test this part about the agreement a little more and the meeting of minds, because the definition of agreement includes an understanding. So if you give me an impression, false maybe, and I accept that as an information that you are giving me, there is an understanding. So the agreement could be an understanding that one party gives to the other and is accepted by the other, even though the information may be false. You are ultimately manipulating the market by giving a false understanding. So why is it not an agreement?
Lordship, here, the opposite parties, when they initiated the discussion, it was about the quantities firstly, and not directly about the prices, Your Lordships. Your Lordship, can you please
I am saying that an understanding that one party accepts the false information of the other and acts on it is an agreement within the meaning of 3A. Is there anything to rebut that, any precedent that you would like to bring? Because it appears that what is an understanding? I present to you something and you accept it. That's your understanding, right? So the parties who took the information, wrong information, the information was also given for the purpose of consumption of somebody and acceptance and understanding, right? So when I give an understanding which is false, but that is accepted and that leads to distortion of the market, or it leads to manipulation of the bidding field, then that's clearly a bit tricky.
right. In Your Lordship, as mentioned by the Honorable Judge here, is that an understanding constitute, if I'm not wrong, that one party sees something, the other party accepts and acts upon it. Your Lordship, however, in the present matter, there is no party who is acting upon it, Your Lordships.
No, but where is this requirement of establishing that it was indeed acted upon?
Your Lordship, as
In the act, can you please tell the section where you think this requirement is emanating from?
Your Lordship, there is no requirement to establish agreement. That agreement has been implemented in the present matter. However, Your Lordship, as the Honorable Lordships referred to the definition that one party says something, the other party accepts and acts upon it. That's why the Council was providing the facts in the present matter. May I proceed, Your Lordships? Yes, Your Lordship. So here, is there any other question from the first leg? Much obliged. So, Your Lordship, here the lack of meeting of mind clearly constitute that there was no agreement in the present matter. However, Your Lordship, if we believe that there was an agreement, the same was not implemented. That can, Your Lordship, please refer to page 2 and para 9 of the memorials. In the case of flashlight market in India, it was clearly held that when there was no implementation, the agreement cannot be established. Further, Your Lordship, in another matter referred to on page 2, para 10, it has been given that in the matter of Indian Railways, a nexus between discussed prices and determination of prices has to be established, Your Lordships. Your Lordship, however, in the present matter, Your Lordship, there is no nexus in what was discussed and what was actually bid for.
No, here I would like to ask you, even though the prices quoted are they are different, but the nexus in terms of the pattern still seems to be appearing. How do you respond to that?
Right. Thank you for your question, Your Lordship. I understand the concern
It's
here.
a prima facie view which is capable of being formed. So why should we not investigate?
Right, Your Lordship.
We are at that stage, right?
Indeed, Your Lordship. So referring to your question first, Your Lordship, I'd like to cite the case of Reprographic India versus CCI, where it was held that it is essential to demonstrate substance and allegation before having a prima facie view. And the role of the council here is to assist Your Lordships to find a proper opinion in the present matter, Your Lordship. Your Lordship, now referring to the question posed by the Honorable Judge here, it was, Your Lordship, that the nexus can be established through the similarity. Now, Your Lordship, answering that, if we believe that the nexus is through similarities, then, Your Lordship, while referring to Americar, Bolger and Battenberg, they bid in the quantities of 450, 430 and 480. Here also, Your Lordship, there is similarity. So, Your Lordship, if in case we say that the nexus is through parallelism, the nexus lies in both the cases. In the case of one group, that is Americar, Bolger and Battenberg, and in the case of another group, that is FMI, Brookwood, Cromwell, Dillon and Maxwell, Your Lordships.
Council, this commission has the ability, right, to direct an investigation to cover other parties as well. So just clarifying to you, are you asking us to bring the other three within the ambit?
Indeed not, Your Lordship. Your Lordship, what the council here meant was that even if we believe that the nexus has been established through this similarity, then, Your Lordship, if we refer to these three other parties, they've bid in 250, 230 and 280. Now, Your Lordship, it is also important to consider that FMI, which was not a party to the discussion here, bids in 200 and also in the price that is parallel with the others. So, Your Lordship, here it can be seen that Americar also, who was a part of the discussion, did not get to win the bid, Your Lordship. However, Your Lordship, further, yes, Your Lordship.
Could it have been a part of a bid suppression kind of a strategy?
Your Lordship, in the case of Americar, as mentioned by my learned opponent, it could be if there would have been a proper discussion and if there would have been a proper agreement in the present matter. However, Your Lordship, the case of FMI was nowhere mentioned by the learned opponent, which clearly establishes that the nexus cannot be established merely on the basis of parallelism, Your Lordship. May I proceed with the arguments? Much obliged. Your Lordship, now moving on to the next leg, that is even if we believe that there was an agreement, it did not cause AEC, that is appreciable adverse effect on competition, Your Lordships. So, Your Lordship, here for reference, can you please refer to page 3 and paragraph 15, a case of Shamsher Kataria, where the honorable courts mentioned that both the positive and the negative factors have to be taken in account while judging whether there is appreciable adverse effect on competition. Here, Your Lordship, the information shared was false information. Further, there is an element of impossibility attached to the information shared, Your Lordships. That is, the total amount comes to 3150. However, it is clearly given that the total amount must be 2800. Now, Your Lordship, it could have created an AEC if the total amount could have been under 2800, Your Lordship. Your Lordship, moving to the second fold that the opposite parties did not cartelize. Your Lordship, there are two essentials for cartelization. Firstly, an agreement as per section 2C. And secondly, that the same aims to limit or control. Your Lordship, firstly, there is no agreement as already established. Now, moving on to the second part, it does not, even if we believe that there was no implementation and the same could not be concluded to limit or control. Further, Your Lordship, it is very essential to cite what has been referred on page 6, para 29 and 30 of the memorial, where it has been clearly held in two of the major case laws, the court has been clear that cartels cannot be punished merely on assumptions or conjectures or flimsy grounds, Your Lordship, or shaky grounds. If Your Lordships have no query, I'd like to move further with price parallelism.
If this is a case of bid rigging, then we have to presume appreciable adverse effect on competition.
Right, Your Lordship.
So therefore, we don't have to enter into a separate analysis.
Right, Your Lordship.
So therefore,
Particularly at the prime officers.
yeah, at prime price.
Right, Your Lordship.
So
The
therefore,
council.
why are you relying on that aspect?
Your Lordship, the council was mentioning that arguendo for the sake of the argument, to have more clarity with the questions that there was no agreement.
So therefore, if there is bid rigging and you are saying there is no appreciable adverse effect, how are you addressing that issue as to why there is no appreciable adverse effect?
Your
You
Lordship.
brought any arguments to address that?
Yes, Your Lordship, there was no appreciable adverse effect as Your Lordship, the information shared was false and had no effect on competition, as already
That
stated.
goes to bid rigging, I think. How does it go to?
Your Lordship, the factors mentioned in 19.3 clearly say that it is an effect-based approach, Your Lordship, that there is limitation of. Yes, Your Lordship.
Okay, yes.
So I should address the question first, right?
Yes.
So, Your Lordship, the factors of 19.3 clearly mention that there is an effect-based approach here. And that's why the council was referring to the facts and clarifying that the effect would not be appreciable adversely on the competition. Moving to the price parallelism argument, Your Lordships. Your Lordship, it has to be emphasized. Please refer to page 7 and paragraph 33 of the memorials. Your Lordship, here it has to be emphasized that in the case of Union of India versus Hindustan Development Corporation, the Supreme Court was very clear in holding that identical prices cannot be the sole ground of holding that there was a cartel. Your Lordship, further, in the case of Rajasthan Cylinder versus Competition Commission of India 2018, the Supreme Court in its landmark judgment was very clear while holding that parallelism is not conclusive of bid rigging, Your Lordship. Further, the court also said that there must be other credible and corroborative evidence, Your Lordships. Further, Your Lordships, it has also been mentioned that factors had to be analyzed keeping in mind the ground reality, which is that often parties share information as a competitive strategy, which is not directly relevant or anti-competitive, Your Lordships. So, Your Lordship, if we refer to page 2 for a plausible explanation, please refer to page 2 and of the proposition. Is there a question, Your Lordship?
Go ahead, go ahead.
Okay. So, Your Lordship, here it has been clearly mentioned that Franconia was a newly discovered compound. Further, Your Lordship, it has also been given that there were more than 100 variables that were to be calculated on a real-time basis. Further, Your Lordship, on the next page, it has been provided that all eligible bidders will have less than 2 hours time frame to decide prices and submit the bids. Further, Your Lordship, it has already been established that the opposite counsel, the parallelism, is in 2 parts, Your Lordship. Firstly, that of the 3 companies that did not win the bid and the 5 that win the bid. So, Your Lordship, here it can be clearly said that price parallelism can be attributed to using of the same algorithm here. Your Lordship, as those who bid for 450, 430, 480, there is also price parallelism that ranges from 107 to 111. Now, those who bid in the range of 200, 240, 270, 230, and 250, Your Lordships, there is also price parallelism that is in the range of 130 to 138 here. So, Your Lordship, here it can be clearly concluded that the parallelism can be the result of the usage of the same algorithm and not collusion, Your Lordships.
So, why can't we see that out of 8, there were only 8 people who got the software, and then there was a attempt to mislead. So some people fell prey to that misleading information. The rest of you benefited clearly from the use of the algorithm. So the parallelism is on account of an unfair advantage that you derived by giving misleading information.
Lordship, the council understand your concern here. However, the information shared was not a relevant factor here to calculate the bid, as my learned opponent said that the bids were to be calculated price per ton. So, Your Lordship, when you calculate price per ton, you do not enter quantity there. This was the argument coming from the learned opponents, Your Lordship.
I suppose it has to be both quantity and price. And therefore, people who had to, thought that they needed to have a higher price, higher quantity, then didn't have enough deep pockets to bid higher. So they sort of lowered the price. So by misrepresenting, you actually eliminated competition. Because there were only 8 people. And, so misrepresentation actually helped to sort of eliminate part of the field which had the BDIR.
Certainly not, Your Lordship. In the present factual matrix has already been stated clearly that the calculated calculation of these 5 comes to 31,3150.
And it seems it was a winning strategy because all 5, even if we presume that there was no agreement to misrepresent, but all 5 thought it was a viable strategy to misrepresent so that it would eliminate competition.
Indeed not, Your Lordship, as FMI was not a part of the discussion here. So not all 5 won. However, the price and the quantity of FMI is quite similar, which can be the result of the usage of the same algorithm in the present matter.
Council, can it also not be part of the fact that the plus factor, because this commission is with you, that parallelism in and of itself, and this commission has always held, is not enough. It's the plus factors that the fact that the 8 met the previous night, that 5 of those 8 exchanged information, the other 3 didn't leave, actually received the information, and everybody appears to have acted on it using the common AI after having had the opportunity to meet. Please explain to us, how are those not plus factors in your instance?
Your Lordship, the 3 plus factors mentioned here is the parallelism, second is the meeting and the discussion, and third is the usage of the same common bid AI. Now, Your Lordship, we'll address this one by one. So, Your Lordship, the meeting has already been established that the discussion was not directly or can be directly used here. So, Your Lordship, moving on to the second fold, that is the usage of the same algorithm, which we have not dealt upon recently. So, Your Lordship, moving to the proposition, here, Your Lordship, on page 3, it has been clearly mentioned, Your Lordship, that bid AI was acquired at rapid pace by various parties, including 8 EV manufacturing companies. Now, Your Lordship, it was acquired by various parties, including the 8 EV manufacturing companies. It is also very essential to highlight that the EV manufacturing companies were interested only in the grade BG40, that is 0.40 of Franconium. So, Your Lordship, when various parties acquired and a particular set of parties are interested in a particular grade, they have to enter factors manually, Your Lordship, to come to a price for that particular grade. Because as per clarification 55, Your Lordship, it has been given that Franconium is used for various other industries also, Your Lordships. Does that satisfy Your Lordship's question? Thank you. Proceeding with the argument, the second issue, Your Lordship, where it has been given that it has been contended that this amounts to collusion. The use of same bid assist algorithm amounts to tacit collusion. Your Lordship, here it is essential to highlight that the role of the bid AI was merely assisting and not decision maker, Your Lordship. For the sake of brevity, Your Lordship, the Council will directly come to 3 case laws that are essential in the present matter. So, Your Lordship, the Council seeks extension of 3 minutes. So, Your Lordship, here in the case of page 10, para 53 of the memorial, in the case of alleged cartelization in the airlines industry 2021, a 2-step test was laid down, Your Lordships. Firstly, that there must be an agreement, and secondly, that the role of algorithm in the decision making, Your Lordship. So, Your Lordship, here, when you refer to page 3 and para 2, it has been given that the bid assist algorithm was one of the bidding assisting algorithm of the aperture. So, Your Lordship, which clearly indicates that there are other bid assist algorithms as well present in the market. Further, Your Lordship, it has already been reiterating that, Your Lordship, here the capacity was merely assisting, which is very, very clear from the proposition. Your Lordship, also there were various players, and the factors for coming to the right price for BG40 would be entered manually, Your Lordship. Your Lordship,
So are you suggesting that this was a customized algorithm in the discovery? It required, it was not uniform across?
Your Lordship, the algorithm was same, but the human intervention in the present matter was extreme, I would say, Your Lordship, because here they had to enter the factors manually for calculating of BG40, for coming to the right price for BG40, Your Lordships.
So, but these factors would have been common across at least these 8 bidders,
Indeed, Your Lordships.
and they were required to enter them individually.
Right, Your Lordships.
And one of these factors will be quantity, which they discussed.
Your Lordship, according to the council, the quantity would be taken into account. However, the learned opponents have said that quantity per ton, price per ton would be decided, and hence, according to the arguments of the learned opponent, the quantity would not be taken into account. May I proceed with the argument?
It's not the arguments of your learned opponent. It's the terms of the tender, right? The tender requires quantity, which is why the chart that you keep taking us to has both price and quantity.
Right, Your Lordship. So, Your Lordship, even if we believe that quantity was an essential ground, it has already been established that the quantity that was discussed and the quantity that actually they bid for was very different. And also, Your Lordship, FMI, the presence of FMI winning the bid, Your Lordship, also establishes that there was no agreement here.
Not for the poor fellows who lost, because, for them it was not that different.
Right, Your Lordship. Your Lordship, is there any question?
Yeah, I'm just saying, so therefore it's not that, you can say that the quantity and the bid quantity was very different discussed one.
Your Lordship,
In
that
all
is
cases, the unsuccessful people actually believed and went forward.
indeed not, Your Lordship. Your Lordship, the unsuccessful people fail to come to a right price because they might have changed the factors that have to be put. Because it has been clearly given in the proposition that there are more than 100 variables that have to be calculated on a real-time basis. The time given, however, is 2 hours, Your Lordship. It is manually not possible to consider each and every 100 factor, Your Lordship, to come to a right price here. May I proceed, Your Lordship?
Please.
Your Lordship, the council will now conclude. Your Lordship, here, the bid assist algorithm would not amount to tacit collusion as held in various case laws, including the Shikha Roy versus Jet Airways, where it was clear that the human intervention plays a major role for deciding whether bid assisting algorithms would be colluding or not, Your Lordship. Here, because there is a human intervention, the same would not happen, Your Lordship. There would be no tacit collusion in the present matter. Much
So
appreciated.
if your intentions were honest, what was the need for you to discuss about this in a social gathering?
Indeed, Your Lordship, the need was uncalled for, but however, in the present matter, Your Lordship, the inherence was to mislead each other and not to form a cartel in the present matter.
In the absence of there being any corroboration, is the doctrine of res ipsa or acquiescer cannot be invoked here? Because facts speak for themselves.
Your Lordship, indeed, the facts speak for themselves. However, the facts are very clear that the intention which has to be taken into consideration was misleading one another. Further, Your Lordship, the discussion that was there in the meeting and the final results were very, very different, Your Lordship. Even if we divide by 2, Your Lordship, there is no straight parallelism here. And I believe that addresses the question of Your Lordships.
Since suspicion is very strong, can't it take the place of proof? You are saying there is no corroboration. When there is strong suspicion, at times that can be treated as proof also.
Indeed, Your Lordship, but Your Lordship, here the responsibility of the council for the opposite party is to establish that the suspicion here is not very strong, Your Lordship, and the opposite parties were not.
Table 5 indicates the
Your Lordship,
page 5 clearly indicates there is some reasonable suspicion in our mind about there being some agreement.
right, Your Lordship. If we refer to table given on page number 5, Your Lordship, it is very clear that there were 2 sets of parallelism, as already stated, Your Lordship, and that cannot help us to easily be suspicious, because, Your Lordship, an algorithm has been also involved in the present matter, where the factors have to be mentioned, Your Lordship. So that there is a strong possibility here that the factors mentioned by 3 of the parties would not be same as mentioned by the rest 5 of the parties, Your Lordship.
Council, your opposite council has shown us that there was an agreement in so much as there was a meeting, quantities were discussed, right? And after that, there appear to be patterns. So now it is not for them to rebut it, right? It is the burden of proof is on you
Indeed,
to
Your
rebut
Lordship.
it as to why this is not a prima facie case.
Indeed, Your Lordship. Your Lordship, the council here has already established that the meeting, Your Lordship, and where the discussion has been conducted, Your Lordship, that does not have a direct effect here for the bidding process, Your Lordship. Further, Your Lordship, it is merely an assumption that in the present case, there lies parallelism. I already established that there are two sets of parallelism, your lordship, and the intervention of the this algorithm also establishes the points of the
But
opposite
then
party.
why are you shying away from an investigation? If you are so confident investigation will bring out.
Right, your lordship, but your lordship, that would certainly waste the time of the court, and the responsibility of the council is here to assist you to come to an opinion that would not only benefit the opposite parties, because here it's not about benefiting the opposite parties. However, it's about saving the competition, your lordships. Much obliged. It was an honor arguing before the bench.
Thank you.
Please.
Greetings of the day to the honorable bench. Your ladyship, for the sake of brevity, the council would like to address the bench collectively as your lordships. Much obliged. Your lordships, with respect to the third issue, the council submits that the remedies sought by the informant exceed the scope of the Bharat Competition Act 2002, and therefore the remedies sought are not maintainable. Your lordships, I intend to address this issue using a triangular approach. Firstly, I shall be establishing that there is no scope for formation of prima facie opinion in the present matter, and hence the BCA has no authority to direct its Director General to investigate the 5 EV companies. Secondly, I shall firmly be demonstrating that the Commission lacks the authority to direct the first auction of Frinconim to be reconducted. And thirdly, I shall be winding up by establishing that BCA has no authority to direct disclosure of bidding metrics to monitoring agency prior to submitting their bid.
Council, have you read the act? Because this commission definitely has the authority to do everything, right? When the facts are right, it is this commission's duty to actually intervene.
So on what basis are you saying that this?
Your ladyship,
ability
I'd like
is
to
absent?
begin with the initial aspect. That is, the council cannot form a prima facie opinion. Your lordship, the council humbly submits that there exists no prima facie case of violation of section 3, clause 3 of the act, as already been emphasized by my co-counsel in the preceding arguments. And as per section 26, clause 1 of the Competition Act, in the absence of prima facie opinion, in the absence of prima facie case, the commission cannot form a prima facie opinion, and thereby cannot direct its DG to investigate in the present matter. Hence, in pursuance of section 26, clause 1, the council pleads the same. Much obliged. Proceeding to the second facet of the argument, your lordship, the council submits the question. The commission lacks the authority to direct the first auction of Frinconim to be reconducted. Lordship, the residuary powers granted under section 27, clause G is not absolute, and passing any order must still be within the larger framework of the Competition Act and not merely section 27. And the authority to direct reconduction of auction cannot be read into the provisions of the Act if we consider reading section 27, clause G, which provides the commission the powers to pass any orders it may deem fit with the clause A to G, your lordships. Your lordships, in the instant case,
I think your opposite counsel is actually seeking that we intervene under section 33, not 27G when it comes to this.
I'd surely like to address that as well, your ladyship. Your ladyship, as per my learned opponent, who has tried to approach this commission under section 33, the council would like to iterate here that the restrictive language of section 33, which talks about the power to issue interim orders of the Competition Act, makes it conclusive that the powers granted to the Honorable Commission for interim relief is explicitly limited to temporarily restraining parties from certain actions until the conclusion of such inquiry or until further orders. And in the instant case, your ladyships, the case prima facie is not of a restraining order, which is evident from the issues that has been raised by the informant as well as the opposite party, your ladyship. If that answers your question, I'd like to cite the case of CCI versus SAIL, where the Trinity test, as my lordship has already pointed out, has been laid down, wherein the court has held that while recording a reasoned order under section 33 of the Act, the CCI should inter alia ensure fulfillment of the following conditions. Firstly, recorded satisfaction, which has to be of much higher degree than the formation of a prima facie opinion under section 26, clause 1 of the Act. Secondly, it is necessary to issue an order of restraint. And thirdly, from the record before the commission, there must be a definite apprehension of an appreciable adverse effect on competition. Furthermore, your lordships, it is further submitted that while considering the balance of convenience, the CCI has to contemplate whether justice is to be best served by passing such an interim order. Now, ladyship, applying the precedent dictated in the sale case in the instant matter, as has already been established, there is no prima facie case in the present matter. In the instant case, the informant further failed to demonstrate any new facts, and that all the facts brought before the commission at the interim stage were based on conjecture. That is, the informant overhears the conversation in the meeting. And thus, the standard envisaged by the sale of having a stronger case than a mere prima facie case is fall short in the present matter. Therefore, as per the first condition, as laid down in the sale case, there is no ground to record his satisfaction to pass an interim order, your lordships. It is further submitted that even if, for argument's sake, the BC had the authority to direct the disclosure of bidding metrics, such pre-disclosure holds no capacity to rectify the harm inflicted by the anti-competitive behavior. Consequently, your lordships, the imperative for issuing an interim order diminishes. Lordships, it is therefore submitted that in light of the same, the interim relief should not be sought.
Assuming we feel that there is a prima facie case, why can't we restrain you from further using the oath that you have taken?
Your lordship, if you may please reframe the question.
Assuming there is a prima facie case that we feel, then the issue of interim order is to be separately addressed, right? We can direct an investigation and issue interim orders or not issue interim
Your
orders.
lordship,
So why should we not restrain you from using the oath further?
Indeed.
That is within the past. You said only restraint orders can be passed, so we can restrain you from using the oath further.
Thank you for your question, your lordships. The council would like to hear submit that the council is addressing the issue number 3 in a threefold manner. The first two issues, the subparts of the first issue, do not talk about an interim order. The third facet of the third issue, which talks about pre-disclosure of bidding metrics to a monitoring agency, that is, the appointment of a monitoring agency should be passed in interim leave. So we definitely do not say that in an interim order cannot be passed.
So
However,
for future, we can do that. So let us say the prima facie case is what your co-counsel has argued, right?
Indeed.
Let us say we are with the complainants in relation to the informants with regard to the prima facie case. Can we not direct that in future some arrangement is there whereby is it so you address the power of the commission first, and
Indeed.
whether we should do it in this case is a different matter.
Indeed.
So you were addressing the power of the commission in that context. Do we not have the powers to ask parties to disclose certain information on which they are bidding to a independent agency for the for the record and for the future information? Secondly, if we feel that there is a prima facie case, can we not restrain you? Does the commission have the power or not? That's the first question.
Indeed, your lordships, it is imperative to recognize that India's competition law framework inherently works in an ex post regulatory framework, wherein actions are taken after assessing their impact on competition. With respect to the matters in question, with the third subpart of the third issue, which talks about the appointment of a monitoring agency, as I can understand is a question that if the CCI can appoint a monitoring agency
For future rounds of bidding.
in future rounds of bid. Your lordships, the council believes that the CCI respectfully lacks the power to do so. And I'd like to establish in this format that when adjudicating matters under Section 3, the approach that is inherently taken by the commission is an effect-based approach, and that is based on an effect-based doctrine. And pursuant to the same, if we are asking in the interim to disclose their bids and to assess the nature of the competition by analyzing the bid by monitoring agency, that becomes a preventive measure and not effect-based approach, your lordships.
So are you suggesting that what the commission should do is actually quash what has been done till now if we cannot at least remedy the situation in future?
Your ladyship, could you please reframe the question?
So in the sense that, because if you're saying that we prima facie feel that yes, there has been a contravention, but you seem to be suggesting that commission appointing a monitoring agency for the future bids and the tenders is power which we do not have, then do you think the position can be, addressed by actually abolishing the tender which has already, or the outcome which has already taken place? Will that be a better approach?
Your leadership, I mean, the remedial direction sought by the informant in the present matter purport to subject the OPs to a regulatory supervision of the CCI and to direct, and it inherently directs how business is to be done. So, your lordships, in doing so, the council submits that the CCI, the commission, would respectfully be transgressing its jurisdiction, and the same is pursuant to the same. The same must not be pursued.
So you're saying this commission can't pass cease and desist also because I tell you not to do something that was done and not to do it in the future. And since I'm telling you not to do it in the future, that's ex ante. Is that what you're saying to this commission?
Indeed not, your leadership. The commission is well within its powers to pass a cease and desist order. However, as far as the appointment of a monitoring agency is concerned, uh, going by the provisions of the Act, there is nothing that suggests that for a violation of Section 3, Clause 3 of the Act, the Commission can appoint a monitoring agency, which would be an ex ante order in the present matter, and hence the Council would like to plead that the same must not be pursued. Your Lordships, if you may allow, I would like to move ahead to the reconduction of auction part, wherein the Council would like to suggest that even if, for argument's sake, we are to argue that the Commission has the power to allow for such reconduction, your Lordships, it is imperative to highlight that Frinconium, the ore that is in question, rapidly loses its qualities once it is extracted from its ore form, necessitating immediate extraction to prevent degradation. Your Lordships may refer to page 2, para 1 and 3 of the Moot proposition for the same. Hence, your Lordships, any delay in this process could render it difficult to extract the Frinconium ore, causing its degradation, thereby rendering the whole auction process useless. Your Lordships, this outcome not only defeats the auction's objective, but also significantly imposes a financial loss on the government. Hence, reconducting the auction is not only impractical, but also in contrary to the interest of justice and national welfare. Additionally, your Lordships, by prolonging reliance on lithium-ion battery, the Council would like to highlight that the Commission would be further exacerbating environmental degradation. Hence, in light of the same must not be pursued. And as far as reconduction of the first auction of Frinconium is concerned, your Lordships, it is further imperative to highlight that a specific law governing auctions, such as the Public Procurement Bill of 2012, is still pending. And in light of the same, in the absence of an explicit provision that vests the Commission the power for reconducting auctions must not be pursued, given it is a power that relies on the government or the executive's authority. Hence, in light of the same, the Council would like to conclude the arguments having established that in light of the absence of a prima facie case, the DG investigation must not be directed, and in light of the preceding arguments, the reconduction of auction must not be pursued, and since the BCA lacks the authority and the provisions of the Competition Act 2002 does not allow such disclosure and appointment of monitoring agency, therefore the same must not be allowed. Your leaderships, if you may allow, I'd like to conclude the arguments by reading out the prayer, if you have no further queries or questions regarding. Much obliged. Your Lordships, wherefore in the light of facts presented, issues raised, arguments advanced, and authority cited, the Council on behalf of the respondent humbly prays before this Honourable BCA that it may be pleased to adjudge and declare that no prima facie view can be formed, as the 5 EV companies have not cartelized during the first auction of Frinconium. Hold that without a prima facie case, the BCA can to conduct an investigation of the 5 EV companies pursuant to Section 26, Clause 1. Hold that the remedy sought by the informant that the first auction of Frinconium should be reconducted falls beyond the scope of the Act, and hold that the power of interim relief has to be exercised cautiously, and here the interim relief sought is beyond the powers of the Honourable Commission, and or pass any other order, direction, relief as it may deem fit in the interest of justice, equity, fairness, and good conscience. It was an honor to argue before the Honourable Bench.
Thank you.
Your Lordship, in leadership, the council shall be taking 2 minutes for the rebuttals. We may start now. Your Lordship, in leadership, the opposite party contended that they met at a government convention. However, the council would like to point out that the meeting of minds need not just be established through direct evidence, but it can also attributable to circumstantial evidence. Now, certain factors like they met the night before, the quantity that is exchanged, and the final bid result. Now, if I may lead the tribunal to the case of aluminum phosphide, in that case itself, the commission had held that when parties enter into the same building before the bid, that can be constituted as a very strong plus factor, which is not considered by the opponent party in this case. Coming on to the implementation of the agreement, Your Lordship in leadership, as per the case of industrial automotive bearings case, it is said that it is implementation of the agreement is not required. And further, in the explanation to bid rigging provided in the Competition Act, it says that just an agreement is required, not the implementation of it. Further, the exchange of the information, that is quantities, was commercially sensitive in nature. Thirdly, Your Lordship and Ladyship, the opposing counsel had taken a lot of instances to point out how Bolger's and Battenberger's parallelism should have also been implicated. But what the council would like to contend here is that the parallelism that is contended of these two parties were very different from that of the 5 opposite parties. That is, in this case, what we're implicating is the usage of the same algorithm coupled with the plus factors, that is meeting the night before and exchanging quantities. And this is how a difference has to be made between Bolger and Battenberger's parallelism, the 5 OP parties. Further, Your Lordship, the OPs, one more thing, that the opposite party contended that price is not a factor, Your Lordship, but with the limited knowledge of mathematics that I have, quantity is taken as a denominator while considering the price per ton. So in fact, quantity is a relevant factor for determining the price per ton in this case, as was accepted by the opposite party. Further, parallelism is not a plus factor, as was wrongly stated by the opposite party. It is a condition for tacit collusion. That is, it is parallelism plus factors for other factors. And just one more thing, that BDI is only relevant to the market of Frinconium in this case, and there are no other algorithms to determine the price of Frinconium ore at this stage.
It has been very vehemently argued that this commission does not have the power to give the reliefs which are being sought. Can you please respond to that?
What relief you want?
Yeah. And also, do you agree with that proposition? What alternate remedies do you think will address your concern?
Can you, if you may repeat your first question again, Your Ladyship?
So it has been argued that the remedies that you are seeking are beyond the ambit or the powers of the commission. Firstly, do you agree with that? If not, why? And what are the alternates which will remedy the situation?
Your Ladyship, if I'm
Prima facie view were to be taken.
If I may take extension of time to answer the question, the remedies that we are contending for is that of re-auction of Frinconium and that of monitoring agency. Your Ladyship, as it argued earlier, it is very pertinent to look at the relevant market in this case. That is a Frinconium ore in this case. And therefore, it's a very new nascent market, and it cannot be allowed that the people who had won the Frinconium ore through a collusive outcome will be able to go forward. So it in fact set a very bad precedent for the future conduct in the market. And that is why the informants is contending for a re-auction in this case, so that the benefits of the Frinconium ore can go to the rightful owners. Further, the monitoring agency is brought about to ensure that there is no further instance of like this until a future or other algorithms that can determine the price of Frinconium come in. So this is just a temporary measure that is coming in till there are future or newer algorithms in the market. And therefore, the balance of convenience is mostly in the favor of the informants in this case, as no harm has been caused, and therefore it eliminates collusion in this case.
Counsel, the question was that your opposite counsel is contesting the fact that this commission has the powers to hear you on these interim reliefs, and in particular, the remedies you are seeking as interim reliefs. So the question is, do you believe that we have the power?
Certainly, Your Leadership, under Section 33 of the Competition Act, the Commission is empowered to issue interim orders. It's a pleasure.
Can't be a reply to a reply.
I think they have a process where they have a.
There can't be a reply to a reply.
Both sides, I think, the form.
That format.
The format.
Just
Your Lordship, here the council will rebut the.
It is an unending process. Again, he will reply to your arguments.
Right.
that is the fear of a judge.
Lordship will not come up with a new argument here. I'd just like to reiterate that firstly, all the circumstantial evidence provided by the opposite counsels have already been rebutted, your lordships. Secondly, the implementation was, as the learned opponents mentioned, that implementation is not required. Your lordship, it was argued in arguendo for the sake of the argument. Thirdly, your lordship, bid AI, as stated by my learned opponent, was used by the EV players, EV manufacturing companies who were the major players. Your lordship, here, as already established through the proposition by stating the facts that EV manufacturing companies were not the only players using bid AI, there were various other players as well, your lordship. Further, your lordship, as per section 33, your lordships do respectfully have a power to pass a restraint order. However, your lordships, as an interim order, your lordships respectfully do not have a power to pass an order for monitoring agency, your lordship here. Much obliged, your lordships.
Anyway, can we have, the court is over, general discussion we can have? No, embargo also. So anyway, both of you did very well. Some small tips for your future guidance. See, whenever you start an argument before a court, you should not say good morning, good afternoon, good evening. You should only say, may it please your lordship. You should commence your argument with that. No other that thing. Second thing is, during the course of arguments, you should not tend to put questions to the bench. You never develop the practice, your argument should tend as if you are putting question to the bench. The bench is not supposed to answer. The bench is only supposed to ask. What I found is, you people are putting questions to the bench. That should not be continued. At best, you can say, asking for myself. Suppose you want to put question to me. You should not say, your lordship may kindly answer this. You should say, I questioning myself. You must put the burden on yourself and then put the question on me. You should not directly say, can we have this clarification on the bench? And you should never say, is the court satisfied with our arguments? Our satisfaction or dissatisfaction will reflect in the judgment. Whenever we ask a question and whenever you answer, never say, is it satisfied? Are you satisfied? Isn't it? There are the basic things I'm telling you. Please don't mistake me, because I take this opportunity of sharing certain things with you. And third thing is, counsel submits is not the proper word. You are a counsel, we know. Every time saying the counsel submits is not the proper. You can continue, but saying that the counsel would like to submit this, the counsel would like to say this is not sufficient. You are a counsel, we know. Okay. Other things are there which you must cultivate, and we are confident that you will do it. You have got the talent, all of you. Wish you best of luck. Come up in life.
On a slightly lighter note, when the bench is nodding, don't invite questions.
And simply because bench put questions, don't think that we are not able to convince with your thing. Only thing is, we would like to know what more we can get. For example, when we asked about the third aspect of the injunction, isn't it? That is very important. Prima facie case, balance of convenience. What is the third one? Irreparable loss which cannot be compensated in terms of compensation. That is very important. So you must also consider on that. If injunction is not granted, the loss that is going to be sustained is irreparable, which cannot be compensated. That should be your argument in the final analysis. Nothing to do with this assessment. I'm sorry if I.
But very useful, and I think that is the idea.
This only your wide experience can provide.
But see if it is okay. We need to sign.
Because it's out of these levels.
Best, best.
Remember your job was very good, but you know, at the end of the day, there were several things that were very good and we were surprised to do. So that everyone finished, you know, and it all comes down to that one last episode. But broadly, there is this combination. Yes, there is enterprise. Also, case you will need to type that out. You're saying you're admitting that they didn't play an active role in facilitating budget cut. That is the case. That means that they don't actually bear. So the manufacturer and they have the manufacturer, same distributor. Imagine your, I don't know, your you have a common distribution, determines my price real time. You know, based on like the offer price check and same point to that. But that's just it. How can you give a common nature? Or you should give a common nature to the distribute your price. That should have been the focus of but then your combination. No, because at the end of it, if it's not an passive, that person decides, if you remember that there is no irony that determines the outcome, there is no agreement to. The driver just signs for another. Fine, we spoke with advocacy sections about sensitivity of wild what's that?
have your expression in the scope of the. This is the number of 86.